Good afternoon to you all. Today's the date set for a preliminary exam. Are the people ready to proceed?
Proceed.
Defense ready?
We're ready.
Okay. Any preliminary matters?
Yes, Judge. So I made an offer, and so it's on the record, so it can be revoked. Circuit Court will do with it as what they will. I would offer that this case conclude aggravated domestic violence. That would make it a 1-year misdemeanor. I believe that a term of 24 months probation would be inappropriate. Some amount of anger management would also be appropriate. My understanding is his family's been referred and they're undertaking CPS services to some degree. This young man who's going to testify before you is nearly 16 years old, and he wants 2 years, knowing that no contact will continue. But my understanding that offer has been revoked. So there's no guarantee that a misdemeanor will ever be made again. That's what I had to place on the record. I'm ready to go.
All right, anything for the record for defense?
Actually, I think his other caveat was it was also under advisement.
That's true.
And all that was rejected.
I was going to give an advisement plea too, and no, so we get 2 years, no problems, things dismissed. I told this the other side of the family, it becomes a non-public record and not a public record.
Okay.
That's what I can do to solve it.
And so the record's clear, a counter offer was made and the gap couldn't be closed, so let the proofs go.
Okay. All right. Well, there's a record of that for if needed, and that's good. So with that, Mr. McComb, should we call your first witness?
Yes, Judge, thank you for calling that.
Good afternoon. All right, step right about there. Yep, perfect. Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I swear
Nope, just say, if you do swear, say yes.
I swear I'll tell the truth.
All right, thank you very much. All right, have a seat. That's the gray chair that I'm gonna have you sit in. And there's a microphone in front of you. It doesn't make your voice any louder, it's just recording your testimony, okay? So because of the glass and the large room, it's hard to hear.
Okay.
And I'm always talking way too loud and they still can't hear me sometimes. And that's gonna happen with you most likely. So we're gonna tell you, keep your voice up. Don't feel bad about that. We have to do it all the time. The attorney sometimes asks me to repeat myself. So just stay a little louder than you normally would, but understand if your voice trails off, we'll just remind you to keep it up. I'm gonna ask that you start by telling me your name and then spelling it for the record. Thank you, Mr. Ruth. And can you hear? Okay, you may proceed.
Need to go probably just 2 ticks more on the volume so everyone back here can hear, okay?
Okay.
Right?
All right.
More?
All right.
Okay. What's your father's name?
Nathaniel Ruth.
You see him here in court today?
Yes, I do.
Point him out, tell the judge where he's at.
He's over there in the corner.
What color tie?
I don't silver, bluish. Thank you.
Your Honor, request identification of defendant, in this case, Nathaniel J. Ruth.
No objection for examination purposes.
The record will reflect this witness has identified the defendant, Mr. Nathaniel John Ruth. You may proceed.
Did something happen on the 1st of September of this year that causes you to have to be here in court today?
That was Thursday, right?
The case of the situation that involved your father in a police complaint.
Okay. Yes. Yes.
You believe that was a Thursday?
Yes.
I had said September 1st. That there was this time something happened this month with your dad?
Yes.
Okay. Where are you at when something comes up that causes you to come here to court today?
On Thursday?
Yes.
Yeah. Okay. I was at my father's house.
Okay. And did there become a time when there was an argument or confrontation between you and he?
Yes.
How did that start?
I was in the kitchen and I was grabbing a baking sheet to put in the oven for dinner, and he grabbed me and I got in trouble at school.
Yeah, let's time out. I'm gonna need you to put the volume back up. Right? Now back up. You said you're at your dad's house, you're in the kitchen, correct?
Yes.
Keep the volume up, please.
Okay.
And there was something about school, right?
Yes.
What happened at school?
I got in trouble in third hour at school. I got suspended for 3 days.
Okay. And did you tell your dad that, or was he aware?
He was aware of that.
Okay. Did you tell him before this time you were in the kitchen, or had he already known that?
He had already known that.
So what do you guys say to one another that leads to an argument?
He asked me where I got in trouble for vaping at school, and he asked me where I had gotten the vape, and he pushed me up against the door with his forearm and said, "Where did you get the vape?" and started hitting. I said, "I found it," and he thought I was lying, so he hit me in the head multiple times.
Why do you say he thought you were lying?
Oh, he said I was lying.
He confronted you in saying you were
He
lying?
said I was lying.
All right.
Thank you.
And you can describe the judge how you were held up. You said something?
With his forearm against my throat, and I had my hands on his forearm, but it was up against my throat right here.
You said you made a gesture with your own
Yes,
hands. Did you
like
say you
this.
had your own arms up?
Yes.
Was it taking the pressure off the forearm that was placed on you by your dad?
Yes.
I'd ask Mr. McCombs, not the leader, give answers, to ask open-ended questions.
No, I think if I develop the testimony, I'm responsive to a physical gesture, I think it's perfectly allowable.
I still believe that that question was leading.
The question regarding, did you put your hand up to relieve pressure from your throat was leading. He had not said that, so it wasn't a follow-up. So that is leading. I'm going to sustain the objection.
Was there pressure being placed on you when you had a cross arm on you like that?
Yes.
What did you do with your hands?
I put my hands on his forearm to relieve the pressure.
And what arm was he using at that point?
He was using his left up.
And did he ever use his right arm in any manner?
To hit me in the side of the head and the back of the head.
Did he say why this is? How does this first become a physical altercation? Had you been smart aleking your dad or what?
I was standing there in the kitchen. The argument started when he had his forearm on my throat.
Okay. You talk back to him?
During the argument, he asked me where I had gotten the vape, and I said I had found it. I did not think that was talking back, but it may have been.
All right. And how many times were you struck with the right hand?
I do not clearly remember, but over 5 times.
Was there any resulting injury to your body?
I had welts on the left side of my head and the back of my head.
Okay. Was that under your hairline?
Under my hairline.
And just for the record, he was gesturing with his left hand, so it was the hair. Did he tell you he was disciplining you for vaping in school when this is happening?
He did not tell me he was disciplining me.
Hey, did Ben talk about being disciplined for being suspended before for 3 days?
There was talk of it, like as in I was not allowed to wear what I wanted to wear, and yeah, I think that's about it. Just I was not allowed to wear what I wanted to wear, and I was grounded. No TV, no computer, nothing like that, but nothing with physical.
Had you defied that discipline that he was laying on you for having a vape pen at school?
No, I changed my clothes and I agree with that punishment.
Where's your dad's place at?
His house.
Yeah.
Flint, Michigan, so 4506. There you go.
That was this month this happened. No further questions.
Cross-examination?
I'm in 10th grade.
What school you attend? How do you do in school?
Objection relevance.
Relevant?
Objection relevance.
You already said that.
Oh,
You
I
don't have to do it twice.
don't know if you're gonna start talking.
Yeah, I was about to answer. You have the right under parental discipline. It's a jury instruction to discipline your child, and that would be in totality of all of the child's things. When we're raising children, we're putting them through school and their attitudes and everything.
I'm gonna allow
else.
that question, but
Yeah.
if it goes further, then I'm gonna make maybe we'll go.
I'm
into
sorry,
it.
Judge, how was this grade relevant?
Mr. Henry has stated that his defense is a disciplinary defense, so if his argument is this is because of discipline, because of grades, then it is something that can be considered. At least something that can be argued.
I can understand it better.
Mr. McCrombs, it's jury instruction 17.244, parental discipline The defendant is not required to prove that the acts of alleged here were reasonable. Prosecutor must prove beyond a reasonable doubt that
I
the
think I
force was
already
not
have,
reasonable.
thank you.
What in the word salad with extra dressing is that?
Would you go ahead and let me know how you do in school?
I have 4 passing classes at the moment. I'm having trouble in school because of stress, and I'm doing okay. I'm trying to get my grades back up.
Last year you almost failed out.
No, I was not reclassified. I was passing to the 10th grade. I passed 5 out of 6 classes. The one class I did fail was an elective course. And I do not have to retake that.
Have you had suspensions before?
No, no suspensions.
And this particular incident, right now you have earrings in as we sit here, correct?
What?
You have earrings in as you sit here today,
Yes.
correct? And what shoes are you wearing?
I'm wearing, my mom bought me these at Great Lakes Crossing. They're just green Vans.
As Mr. McComb said, if you could speak up a little, I can't. hear you.
They're green Vans. They're
Green Vans.
suede.
Is it fair to say that your
Vans
parents,
with a V.
Yeah, Vans with a V.
is it fair to say that your parents had consulted with one another after you were suspended from school for vaping? And part of your punishment was not having earrings and in fact not being able to wear the Vans that you have on right now?
Yes.
And you would agree that both of your parents discussed with one another how to discipline you. Would that be fair to say?
Yes.
And they reinforce one another's punishment, is that correct?
Not all the time, no.
Usually though?
Not really, no. This is the first time in a very long time.
Okay.
And then just for clarification, this is the first time that what?
They agreed on
That they
punishment.
agreed. Okay, that's what I thought your answer meant, but I just, okay.
Anything at all, really.
And just kind of laying who you live with and everything else, is it fair to say?
Attorney
up
Henry,
in-
I don't mean to interrupt, but I need to take a break for about less than 1 minute.
You're fine.
I'll be right back, and I'll be right back. So you can stay right where you are.
Okay. Thank you.
A little bit of a longer break, but not much, and I have been handed a misdemeanor plea agreement, so maybe the break was meant to be. So, Mr. McCombs, if you could please state that agreement for the record.
Yes, Judge, I referred to it earlier, off the record, that this case we have charged as child abuse 3rd degree, it's 2-year penalty. We in this instance to agree to reduce that to aggravated domestic violence 1 year and $2,000. People dismissal counts, however, we would not object to this plea being put in and taken, considered by the court under MCL 769.4A, the so-called advisement statute. With relation to any sentence, we've agreed that while I had some specific terms in mind, we leave certainly to the sound discretion of the court at the time of sentencing. I would not anticipate there being an incarceratory sentence, at least the initial sentencing. We would anticipate a probationary sentence. Having said that, that's a complete recitation of the agreement we've reached today.
I would agree.
Okay, Mr. Ruth, did you hear the plea agreement?
Yes, ma'am.
Do you understand it?
Yes.
Do you understand that pursuant to the plea agreement, the offense that you'll be entering your plea to today is entitled aggravated domestic violence? That is a 1-year misdemeanor and or a fine of $2,000 is the maximum possible penalty. Do you understand that?
Yes, Your Honor.
All right, and you are asking the court to consider taking that under 769.4A, which would make this a non-public case and defer the conviction. If you successfully complete a probationary sentence, the case would be dismissed and kept as a non-public file. If you violated terms of probation, depending on the violation, a conviction would enter and you'd be sentenced accordingly. Do you understand that?
Yes, Your Honor.
All right. Also understand that if your plea is accepted, you will not have a trial of any kind, and you'll be giving up all the rights that you do have at trial. The rights you are giving up the rights are listed on this advice of rights and plea information form that I'm holding up that now bears your signature at the bottom. Did you read and understand all the rights on this form?
Yes, Your Honor.
You understand you'd be waiving those rights if your plea is accepted today because you would not have a trial of any kind.
Yes, Your Honor.
Are you on probation or parole for any offenses today?
Just this one, Your Honor.
Okay, so no. All right. Has anyone made you any promises to get you to plead guilty today that we have not talked about on the record today?
No, Your Honor.
Has anyone threatened you?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes.
All right, understanding the maximum possible penalties and understanding all the rights you are giving up. How do you plead to aggravated domestic violence?
Guilty.
All right, sir, I'm gonna take you back to on or about September 1st. It says September 2nd on the complaint, but September 1st is a Thursday. So on or about September 1st or 2nd, were you at home with your minor son? And let's see, I do have.
May I, Your Honor?
Yes.
Were you at home that day with? Yes. And he, as you heard earlier, had he been suspended for a few days for having a leave at school? Yes. And had you had some behavioral issues in the past with your son? Absolutely. And were you addressing that and dealing with it? Attempting to. And I think your version differs a little bit from his. Did you at one point in time have him up on the wall and talking to him? Yes. And is he the first one that turned it into an actual punching type event? Yeah.
We don't have much of a plea here.
Well, and then eventually you did hit him in the head in response to that. Yes. And you understand that I've spoken to you and advised you that you have the right as a parent to parental discipline, and you talked about the thresholds for all of that and everything else. Yes. And I've also explained to you the right of self-defense. If somebody uses physical force, you can use the same amount of force. Yes. And you're willing to give up both of those claims of defenses and acknowledge that you did put your hands on your son originally, holding him up by your elbow against the wall. Would that, you agree with that? Yes. And you would agree that that was harmful and offensive contact, and he didn't want that contact? It was not, correct. And that it left some kind of a mark, the first initial portion left some kind of a red mark on his face, neck area from holding him up on the wall. You would agree with that? Yes. And you would agree that that's an injury? Yes. And again, he's in your son and lives with you under your parent custody. Well, did at this point in time? Yes. Any further questions on the factual basis?
Yes, you agree with me, Mr. Reed, you got about 100 pounds on your son, don't you? He's a skinny kid.
Thereabouts, he's put some weight on me.
But you're a bigger man than he is, at least right now, right?
It's arguable. We have a hold
I'm just saying right here, he's a kid's a beanpole right now.
Yeah, he's strong.
You got 100 pounds on him, don't you?
Yes. Well, I don't want to get into all those semantics. Mr. Ruth, did you almost die a year ago and you had a broken back, broken neck, you have a club foot that doesn't work and you can barely move? A rod in my leg and, yes. But again, I don't really want to get into that. I'm not asking you to accept the plea. I think we get the factual basis.
I do. I'd have to give each attorney an opportunity to ask, but I did that, and I do agree that, Mr. Ruth, I do agree that I do have a factual basis to accept your plea. However, I am going to take that plea under advisement for consideration of 769.4A. I am going to order a pre-sentence investigation report and set sentencing for November 2nd at 9 a.m. if that date works for you, Attorney Henry.
Yes.
Okay, that is your sentencing date. We're gonna give, did we give them paperwork, Misha? We're gonna give you paperwork to go right across the hall. It will be done by telephone. The report will be done by telephone, so, but you gotta get your date, so that's important. Okay, you understand? Mr. Ruth, you understand?
I'll get through that.
Okay.
You take the tether off, Judge?
And that's what I'm gonna deal with now. And there was also a discussion about tether off the record, and Mr. McCombs, you had stated you had no objection to the release of
I think
tether.
there's probably adequate safeguards in this case.
I do agree.
Tried to talk or had to put this child up with. He wanted this to not be a felony, I can tell you that, because I may not be here at the sentencing. But I think with having said that and what Mr. Henry has said about Ms. Green, that there should be adequate safeguards for everybody.
Okay.
And Judge, being totally honest with you, Mr. Ruth's gonna just kind of step back and, as I've already stated, when he's ready for it, whether it's 1 month, 6 months, he'll address it then, but he has no intention of trying to have any contact. He's upset by this whole thing himself, to be honest with you.
All right, well, Mr. Ruth, I have no indication that you're not going to be compliant with CPS and you're not going to be compliant with the bond conditions. So you know that as of right now, and it's probably in the best case right now, to have no contact with your son, and that is the order of the court. You are to have no alcohol, no illegal drugs. You are to make all your court proceedings, and you are to go to probation and get your present his investigation report and comply with CPS, and tether may be removed. Tether is on you. If you're under the conditions of tether till it's physically removed from your body, we're gonna give you an order. Have a bond condition form that I can, yep, perfect. So if you violate tether on the way to get it removed, the deputies don't know, so they'll come arrest you, and then, once they can find me, then I could say, oh, I signed the order. So you're
I'll
on
walk him through
tether,
the process to make sure he gets it.
you're on tether till it's removed from your body is all I'm trying to say, to
Yes.
save you from any of that issue, Mr. Henry.
Judge, the only other thing, just to clarify, and I let Mr. McCombs know 15, and then he has a daughter that I think is 12. And he intends to continue to exercise spending time with the daughter. His ex-wife has pumped the brakes, uses kind of as a parachute to pump the brakes as everything, so everyone's clear on the record. This has nothing to do with his 12-year-old daughter. What happens at family court might be different, but I just want it clear that unrelated to the daughter.
If I understand correctly, that's kind of being supervised by the authorities of the family court, CPS.
Okay, I know nothing about that, so I'm not even going to speak on that, but I think my bond conditions are clear. No contact with your 15-year-old son.
Well,